Now, today in this class, we are taking into account the doctrine of privity and other topics. Okay, doctrine of privity. So, what do you mean by this doctrine of privity? Stranger to contract is nothing but doctrine of privity. Okay, when you go for a contract, there should be two persons. There should be two persons, offerer and offering. Okay, and there is no chance for any other person or an outsider or a person who is not related to the agreement. We'll call him as a third party or stranger. So, when we come across stranger to stranger to contract. Okay, not consideration, stranger to contract. We'll call that thing as doctrine of privity. In it is general rule of law states states that only parties to a contract may sue and be sued. This rule is known as doctrine of privity of contract. That is, when you take into account an agreement, okay, the offerer and the offeree only they must be sued and be sued by other people. One person he can sue the other person, and other person he can sue the first person. So that thing we will come across when we go for doctrine of privity. Privity of contract means relationship existing between parties who have agreed into contractual obligation. Okay, doctrine of privity. What do you mean by that? Privity of contract means relationship existing between parties who have agreed into contractual obligations. Okay. Two consequences of privity of contract are: first one, a person who is not a party to a contract cannot sue upon it even though it is for his benefit and he provided consideration. So, this is very, very important, Amma. A person who is not a party to a contract, okay, that is nothing but a stranger. A person who is not a party to a contract cannot sue upon it, he cannot go to court of law, even though it is for his benefit. Okay, even though it is for his benefit and he provided consideration. Okay, even though he give consideration, even though it is for the benefit of the stranger, but he cannot sue upon the contract. Only the parties to a contract having the contractual obligation, only they are supposed to sue and be sued by other. The second thinking is a contract cannot confer rights or impose obligations arising under it on any person other than the parties to it. A contract cannot confer rights or impose obligations arising under it on any person other than the parties to it. Okay, the contract also it is okay. It is not okay having the authority to go for a stranger to a contract. And there is a beautiful case in this: Dunlop Pneumatic Tires Company versus Selfridge Company. This is a very, very important case that we come across. Dunlop Pneumatic Tire Company versus Selfridge Company. Okay, in this, what is the case and what is the judgment that we come across? Yes, purchased tires from Dunlop Tire Company and sold them to D, a sub dealer, who agreed with Yes not to sell these tires below Dunlop's list price. It has to pay Dunlop Company £5 on every tire so sold. Later, D sold two tires at less than the list price, and Dunlop Company sued him for the breach, for the breakdown. Okay. Yes purchased tires from Dunlop Tire Company and sold them to a sub dealer D. And while selling the tires to the sub dealer D, Yes Limited, he told that you should not sell the tires below the list price of Dunlop Company. Below the list price of the Dunlop Company. And suppose if you sell that, you have to pay a penalty of £5 per tire to Dunlop Company. Okay, who agreed with yes not to sell these tires below Dunlop's list price. It has to pay Dunlop Company £5 on every tire so sold if we sell that below this list price. And what D had done is he sold two tires. Okay, later D sold two tires at less than the list price of Dunlop list price, and Dunlop Company sued him for the breach, for the breakdown of this. Okay, breach means breakdown. What is the judgment? The Dunlop Company could not maintain suit as it was stranger to the contract. As it was stranger to the contract. Okay, here the contract is between S and its sub dealer. And Dunlop Company, he sold the tires to S Company Limited. And S Company Limited, he told to his sub dealer D not to sell the tires below the list price of Dunlop Company. And suppose if he sell below the list price, okay, on every tire he has to pay £5 to Dunlop Company. Okay, and this gentleman, sub dealer D, he sold two tires below the list price, and Dunlop Company it sued in the court of law. Okay, for the breakdown of the contract. So, what is the judgment given by the law? Okay, the Dunlop Company could not maintain the suit as it was stranger to the contract, because the contract had between yes and its D, that is sub dealer. But Dunlop Company is no way concerned. Dunlop Company is no way concerned. Okay, so here Dunlop Company is completely a stranger to the contract. So he can the whatever it may be the suit, whatever it may be the suit that was filed by Dunlop Company, it is not valid. So this is nothing but the doctrine of privity, that is stranger to contract. And here also you'll come across some exceptions. Okay, here also you'll come across some exceptions. What are the exceptions that we come across? Trust or charge. Trust or charge. A person called beneficiary in whose favor a trust or other interest in some specific immovable property has been created can enforce it even though he is not a party to the contract. Okay, this is the important thing that we have to take into account. A person called beneficiary in whose favor a trust was established or other interest in some specific immovable property has been created can enforce it. He can enforce it even though he is not a party to the contract. Even though he is not a party to the contract. Example: A agrees to transfer certain properties to be held by T in trust for the benefit of B. B can enforce the agreement even though he is not a party to the agreement. Here, A and T are the persons. A and T are the persons. But who is the beneficiary? B is the beneficiary. B is the beneficiary. So B can enforce that. B can enforce the contract. But even though he is not a party to the contract, this B is not at all a party to the contract. It is between A and T. The contract is between A and T, and the beneficiary person is B. B can enforce the contract, but okay, B can enforce the contract, but we have to see whether B is a party to the contract. Even then, if he is not a contract, he can enforce that. That is nothing but trust or charge. Next, Marriage settlement or other family arrangements. Marriage settlements. When we go for marriage settlements, okay, it is between the bride's family as well as bridegroom's family, the contract. But thing is, okay, another person, that is mediator, a broker, he will enter and he will see that the contract is carried on. And why he can do that? So it is for the benefit of the bride. It is for the benefit of the bride he is entering into a contract. So there, okay, he can enforce the contract. But thing is, okay, even though he's a stranger, he can enforce the contract. When an arrangement is made in connection with marriage, okay, marriage, partition, or other family arrangements, a provision is made for the benefit of person, even though he is a stranger to the agreement. Okay, when we go for a family arrangements or marriage settlements, whatever it may be, even though a third party, when he comes, okay, when he comes, he can enforce the contract. The benefit must be with the person, that is either of the persons. Now, carriage, Dor- Doropati versus Jaspat Roy. Okay, Doropati versus Jaspat Roy. This is a case, important case that we come across. Jed wife deserted him because of his ill treatment. Okay, Jay entered into an agreement with his father in law to treat her properly or else pays her a monthly maintenance. Okay, Jay wife Jay's wife deserted him because of his ill treatment. He is not, I mean, treating properly and he is not living properly. So that's why Jay's wife, she deserted Jay. Jay entered into an agreement with her father, not with his father, with her father in law to treat her properly or else pays her monthly maintenance. Later on, she was again ill treated and driven out. Okay, Mr. J, he entered with the wife's father that he will behave properly or else he is going to pay some maintenance to her. Later on, she was again ill treated and driven out. Okay, again, later on, she was again ill treated and driven out from the house. Judgment. She was entitled to enforce a promise made by G to her father. Okay, she can go to court of law and she can file a suit because it is nothing but a promise made by J to her father. This is about the important case that we came across. Doropati versus Jaspat Roy. Okay, ma. Now we are going for the next one. Acknowledgement or estoppel. Acknowledgement or estoppel. Estoppel means, okay, he is a person, even though he is not related to any this thing, but in the public he seems or he pretends that he is well known about the parties. So like this, you'll come across estoppel. And this word estoppel, you'll come across when we go for partnership business. Partner by estoppel. Okay, what do you mean by this? He is nowhere concerned with the partnership business, but in the public, he will pretend that he is one of the partners and the partners will hear his words. Like that, he will create an image in the public. But actually speaking, he is nowhere concerned with the partnership business. Like that. When the promisor by his conduct acknowledges himself as an agent of a third party, a binding obligation occurs. When the promisor, that is when the offerer, when by his conduct acknowledges, okay, acknowledges himself as an agent to a third party, then you will come across a legal binding obligation. Okay. Example: A receives a sum of money from T to be paid to P. A admits this receipt to P. A admits this receipt to P. P can recover the amount from A as he was regarded as an agent. A receives some money from T to be paid to P. Okay. Okay. A person, he receives some amount of money from T. Okay, why he receives that amount, he has to pay to P. P admits this receipt. Okay, P told yes. Okay, A admits this receipt paid to P. A admits this receipt to P. Okay, he agrees. Okay, for receiving this, P can recover the amount from A as he was regarded as an agent. P is regarding Mr. A, as his agent. So in this case also, you will come across the legal binding, even though the person is a stranger. Next, contract without consideration is void. Contract without consideration is void. Or you can say that no consideration, no contract. No consideration, no contract. Okay. Okay, when there is no consideration, when there is no consideration, the contract will not stand. And this thing, it will have some exceptions also. It will have some exceptions. In some cases, even though there is no consideration, even though there is no consideration, the contract is said to be valid. What are the things? Love and affection. Love and affection. You see, for example, a father, he will look after his son. He will look after, he will pay all the things, and he will do everything for his son or daughter. Okay, for his daughter. And there he won't anticipate any consideration. There you won't come across any consideration. Why? Because out of love and affection, he thought that, the father, he thought that it is his duty to do that. So there, okay, as a matter of fact, there should be consideration. As a matter of fact, there should be consideration, but here consideration is not there. So out of love and affection, he is doing his duty. So that is very, very important. So the first exception is the general I'm just reading the top one. The general rule is that ex nudo the monoritor monoritor actio. Okay, this is nothing but a Latin word, Amma. This is nothing but a Latin word. Ex nudo nono ritor actio. Nono ritor actio. This is nothing but one Italian word. The general rule is that ex nudo nono ritor actio means any agreement made without any consideration is void. The general rule is okay, no consideration, no contract. There are some the exceptions of this rule. In such cases, the agreements are enforceable even though they are made without consideration. Even though they are made without consideration. Okay, among that, the first one is love and affection. When an agreement is expressed in writing and registered under law on account of natural love and affection, okay, between the parties, it is enforceable even though if there is no consideration. Even though there is no consideration. So, love and affection. Okay, for example, F out of natural love and affection promises to give his son 1,000 rupees and put his promise in writing and register it. See, you have to write and you have to register that. Okay, there is no consideration from P. There is no consideration from P. But out of love and affection, this F, he is giving his son 1,000 rupees. So there is no consideration from P, please. Even then, it is enforceable by law. Now, compensation for services rendered. Compensation for services rendered. A promise to compensate wholly or partly a person who has already voluntarily done something for the promisor is enforceable even though without consideration. Okay, a promise to compensate wholly or partly a person who has already voluntarily done something for the promisor is enforceable even though without consideration. I'm reading the example. X finds Y's purse and gives to him, gives to him, where Y promises to give rupees 50. This is a contract. This is a contract. X finds Y's purse and gives it to him. He had given that. Y promises to give 50 rupees. This is a contract. Whether he is going to give or whether he is not going to give, it's a secondary issue. But this is a contract. Okay, because he had done some service. Okay, for compensation for services rendered. Okay, whether the compensation is there or not, it's a secondary thing. But thing is, when you come across some services, when you have done some services, okay, to the promisor or to the offerer, then automatically you'll come across some compensation, and then that contract is said to be valid. Promise to pay time bar debt. The second thing, I mean, the third thing is promise to pay a time bar debt. Say, for example, X and Y. Okay, X owes some money to Y, and it is time barred. And it is time barred. And when Z comes and when he promises that he is going to clear the debt, then it is a contract. Here, there is no consideration to Z. Okay, here there is no consideration to Z amount. Okay, a promise by a debtor to pay time bar debt is enforceable provided it is made in writing and is signed by debtor or his agent. A promise by a debtor to pay time bar debt. Okay, a promise by a debtor to pay time bar debt is enforceable provided it is made in writing and is signed by the debtor or his agent. Okay, he can pay the debt or his agent can pay the debt. Okay, there when his agent, when he is paying, even though there is no consideration, even though there is no consideration, but it is enforceable by law because it is nothing but an exception to the, I mean, this thing, contract without consideration is void. Now, completed gift. Completed gift. The fourth one is completed. No, the rule, no consideration, no contract act, the no contract does not apply to complete gift. When you are going to give a gift, you have to see whether it is a complete gift or a partial gift. When you go for a complete gift, then even then, okay, even though it is not having, there is no contract, then it is enforceable by law. And here you have to observe one thing is whether it is a complete gift or a partial gift. When you go for a partial gift, okay, there should be consideration. When it is a completed gift, okay, then there won't be any compensation. Even then, it is enforceable by law. Agency. No consideration is necessary to create an agency. Okay, there is no necessity for you to create an agency. You can create your agency. So, like this, you'll come across, and with this, we are completing the topic consideration. Tomorrow, we are going to continue this.